Hi, let's have a look at communication of offers and the different ways in which an offer can be terminated. For communication to take place, it can be orally, in writing, or it can be implied by conduct as well. However, what is important is that it has to be communicated to the offeree, that is the person to whom the offer is actually made. Now let's have a look at the different ways in which an offer can be terminated. Firstly, rejection. So if your offer is rejected, that's it. It comes to a point of termination. But there are other ways in which it can be terminated as well, which may not be expressly brought about in the first instance. So for example, if a counteroffer is made, then that means that your initial offer has been put off the table, and that is why it is rejected. Second of all, one has to make a distinction between whether the offer is being rejected through a counter-offer or the offeree is asking for more information. So in my previous example of selling you my car for £10,000, if you come back to me saying that what is the make of the car, what is the reg, what is the model, what is the color, etc., that is not a counter-offer. That is just you seeking more information and the offer still stands. Second, revocation of an offer. So up until the time before you have actually accepted my offer, I can revoke my offer at any time. However, once you have accepted it, I can't revoke the offer after that. Let's say if in my offer I were to tell you that you have until Friday for you to either accept or reject my offer. But on Thursday, I sell the car to a third party. Can you still hold me bound? Saying that the offer you made, that the offer I made actually prevented me from selling the car to anyone up until Friday. Now, this was a question which was considered in the case of Dickinson and Dodds, which was decided back in 1875. The court held that anything that I said was just a promise and nothing more. It did not bind me to a contract because even you did not do anything over, above and beyond to hold you contractually bound to this promise. And therefore, this is in contract law what we refer to as meeting of the minds. The third way in which an offer can be terminated is through the relapse. And this can happen by 1, death of a party, number 2, passage of time. So if the acceptance is not made within the time prescribed by me, the offer will lapse. And thirdly, non-fulfillment of a condition. So if you were to fail to fulfill that condition, the offer will lapse. And those are some of the primary ways in which an offer can be terminated. Thank you.